Good day to everyone. Now I'm here to speak on the registration requirements for a person who is engaged only in exempt supplies. So that it is becoming quite a debate nowadays when it comes to requirement of registration under the GST Act. If a person is only into the supply of exempt commodities and services, exempt goods and services. So to answer this question, whether the registration is required or not, we would have to refer to three sections basically: section 22(1), section 23, and section 24. So let us look at these sections and let us try to analyze and come to a conclusion whether registration is required or not. So let us look at section 22(1). Basically, it is 22(1) that to the first paragraph alone is sufficient for us to give a conclusion prima facie. Every supplier shall be liable to be registered under this Act, the state or union territory other than the special category states from where he makes a taxable supply of goods or services or both if his aggregate turnover in a financial year exceeds 20 lakh rupees. So this alone is sufficient to come to conclusion that if he makes a taxable supply from a state where the aggregate turnover exceeds 20 lakhs. So now, what are the conditions over here? There are basically three conditions: that he should have made a taxable supply, number one. Number two, obviously it should be in a state. And number three, and that the turnover should exceed 20 lakh rupees. Now, the one of the basic conditions over here for registration under 22(1) is he should have made a taxable supply. Now, let us look at section 23. This is that section which exempts registration for those who are engaged in exempt supplies. Now let us look at the wordings. The following person shall not be liable to registration, namely. Therefore, the word used is namely, which is only a restrictive clause, which means only those who satisfy the two conditions given below are exempted from taking registration under the GST Act. Any person engaged exclusively in the business of supplying goods or services or both that are not liable to tax or wholly exempt from tax under this Act or under the Integrated Goods and Services Tax Act. Therefore, what emphasis that has to be made over here is that any person who is engaged exclusively means there shouldn't be any other non-exempt supplies being made which are not liable to tax or wholly exempt from tax. But not liable to tax, and we'll have to again go back to a definition of non-taxable supplies. Non-taxable supplies are those that are not leviable under the GST Act or under the IGST Act. That is number one. Number two, that which are wholly exempt and partially exempt. Partially exempt suppliers are not liable, are not given this exemption, which means they'll have to take a registration, whereas for those who are wholly exempt under this Act, they need not take registration, is what this section reads. And number two, an agriculturist. An agriculturist, it's a defined word again, to the extent of supply of produce out of cultivation of land. So all those involved in agriculture activities and anyone who is engaged only in supplying of exempt goods or services need not take registration. Now these two sections are very clear. Now why the confusion has arisen is because of section 24, which deals with compulsory registration. So compulsory registration means that even if the condition specified in section 22(1), that is that which we read a few minutes back, is not satisfied, one would have to compulsorily register under the Act if the following conditions are there. If he satisfies any of these given conditions, 10 to 11 conditions have been given, and that which would make an exempt supplier be registered under the Act is one of the conditions, where it says that a person who's liable to pay tax under reverse charge. That is that condition that which creates confusion as to whether an exempt supplier is supposed to take registration or not. Let us look at the other conditions as well. Person making any interstate supply, obviously there is a notification also along with interstate taxable supply 10/17, which says that 20 lakhs if the turnover is there is no requirement for you to take a registration. And casual taxable persons who are required to pay tax under reverse charge, persons who are required to pay tax under 9(5), which has again been put to deferment till 30th September. Non-resident taxable persons making taxable supply, persons who are required to deduct tax under 51, and persons who make taxable supplies on behalf of other taxable persons, whether as an agent or otherwise. The agents are supposed to get themselves registered, ISDs, and then persons who supply goods or services or both, other than supply specified under section 9(5), through electronic commerce operator who is required to collect tax under section 52. And every electronic commerce operator and every other person who is in the business of OIDAR, that is online information and database access and retrieval business, and such other person that must be notified, as may be notified by the government. So these are the following persons who have been listed to take compulsory registration under the GST Act. Now, what makes an exempt supplier be forced to take registration under the GST Act is the operation of clause number 3, persons who are required to pay tax under reverse charge. Let us look at the situations when an exempt supplier engages a person on which the liability to pay tax is on a reverse charge basis. For instance, he may engage a lawyer, or he may engage a goods transport agency, agent services, or he may also import certain services. So if that being the case, he will have to pay tax on a reverse charge basis. And now the confusion arises whether the registration would have to be taken under section 24, or one can rely to section 23 and not take any registration. This is the confusion. There are 3 judgments of the advanced ruling where people have gone and approached the AAR to get a ruling on this same situation, and in all these 3 cases, all the arguments have been placed stating the wordings of section 24, which says, notwithstanding anything contained in subsection 1 of section 22, which is the non-abstinent clause. When this clause is put to operation, which means that it has overridden the requirements of section 22. Now the arguments are such that this 24 takes into consideration those cases where 22(1) has failed, that is where the aggregate turnover is less than the required limits. So if a person is into exempt supplies, this section 24 nor section 22(1) will be applicable, because it will become redundant in nature. Hence, people have they have argued in such a way that 23 is an independent section, and 24 and 22(1) are only dependent with each other. Now, what the courts have said, or in fact what the benches have said, is that they are supposed to take registration requirements by virtue of 24. There is no other solution out of it if he is having any reverse charge mechanism. However, they are anyway eligible to claim exemption, and they'll have to show it as exempt supplies in their returns. That is what the ruling has come in all the 3 cases. However, if we look, but these are only advanced rulings, it is not a Supreme Court or a High Court judgment. Advanced rulings are only applicable to that SSE and to that proper officer, and hence one can take a cue of how the court would be thinking. However, none of the 3 cases is argued on the lines of the wordings of section 22. Section 22 says the basic condition required for 22(1) to be attracted is the supply of taxable supplies. Taxable supply you will have to provide, and then the turnover has to exceed the limits. Then 22(1) will be operated, and you will have to take registration under GST. If either of these two conditions are not satisfied, that is, if the condition of aggregate turnover is not satisfied, 24 comes into picture. However, if 20 to 1, if you are not even providing taxable services, where is the question of 20 to 1 into picture at all? That is the area where the arguments had not been placed. Hence, if the exact wordings of 20 to 1 is taken into consideration, it says that a person who supplies taxable supply from a state where the aggregate turnover exceeds 20 lakhs. However, if he makes a taxable supply and however, if his turnover is less than 20 lakhs, then 24 will come into operation. However, if he is not making taxable supply at all, then 20 to 1 is out of picture itself. Hence 23 is what we'll have to refer, and there won't be any requirement of registration if he is making only exempt supplies, even if he may have any reverse charge obligations. However, it is always, this aggressive view is always subject to litigation, and one may expose himself to departments and inquiries, but such a bold stand has to be taken when the law itself is quite clear with the wordings. Thank you.